so in love with you. You got me down again.
Check 1, 2. Hello, everyone. I'm Leonard French, your favorite copyright attorney. Before we begin, can I get a feedback from chat? How the audio is? Am I synced? Am I loud enough? Am I clear enough? Am I pretty enough? What do you say? I know there's a delay here, so there's going to be about 5-10 seconds before anyone says anything back to that. So, the result is penis. No. No, the result is not penis. Sound levels are great. Haiku Knives, thank you very much. Audio is Gucci. Awesome. What a weird cat. Audio is great. Sid, thank you. Okay, jeez. Okay, chat blew up. You guys got all that. So it's like a 15-second delay. Excellent. Well, hello, everyone, and thank you for joining me. Thank you for the 50 Swedish kroner, whoever that was, in the very beginning. Insert defaming and or slanderous statement about Mr. French here. Well, then I will insert a hypothetical defamation lawsuit back. Haha! Your move. We are here to talk about Alex Mauer. I'm still petting the dog. And go lay down. I'm sorry. I'll get back to you later. We are here to talk about Alex Mauer and DMCA, copyright abuse, extortion, the legal consequences of this, and you may have noticed I put some things scrolling across the bottom because I'm also going to offer my services in whatever way possible. I'm not the one lawyer who's going to take care of everything, but I'm offering to be part of an effort to pursue this person, as they may or may not be local to me. I don't have conclusive evidence or research on that, but everything seems to point to that this person lives very, very close to me, and that puts us in the same jurisdiction. That means that I can take actions in local courts a whole lot easier than I can take actions in foreign courts. So, what are we talking about? Mark, thank you for the $5. I am a pretty princess. There is nothing wrong with being a princess, at least not in concept. I think we see a lot of execution, and there's definitely some derogatory things said about real princesses in the dating world. But we're not here to talk about that. Although it is Sunday, I am a little casual. I'm wearing my Carhartt t-shirt and my Tractor Supply hat that I picked up yesterday. It was so cool yesterday. It was a nice spring morning, and then it went boom right to summer. So I had to change, and I picked up some new clothes, and here we are. So what are we here to talk about? Alex Malware and DMCA copyright abuse. Let me pull up my outline, and we will get started. So what has happened? So their background information. Alex Malware is a music composer, producer who works for or on contract or works for various organizations writing music for sound she has in the past I don't know, somebody just blinked on my screen. I have no idea what that was. She has in the past written lots of music for games and things, and I've seen some forum posts and things that she enjoys making the kind of electronica sounds and things. And that's great. She agreed to produce music for a video game called Starmazer, and apparently also a subsequent game called Starmazer DSP, working with a video game company called Imago Softworks, I believe. We're going to look at the contract in a moment so we can verify all of that. And all of that's fine. There was apparently a contract dispute. Perhaps she didn't get paid or something like that. And instead of handling that dispute right there at the contract level, instead she began issuing DMCA takedown notices to channels who had used footage recordings of the game of Stargazer DSP and Starmazer, Starmazer and Starmazer DSP. Pardon me while I wet my whistle. So that's where it starts to get interesting, because you're not allowed to use the DMCA in that way. She's not allowed to issue copyright strikes against channels if she doesn't own copyrights, or if she's just asserting a contract dispute with the producers of the game. Where does DMCA come into this? Well, she claims to own the copyrights or own the right to use to assert the copyrights in this way. And so several other videos and commentators, and I've also commented on, not offline but off YouTube, that that's not really how this works. She would sort of have to have an explicit copyright assignment, and every piece of evidence that I've seen so far says that she does not have a copyright and instead has assigned her copyright to the company she works for, which is normal. When you work for a company and you create copyrights for them, they own the copyrights. It's not like, and I can see how this gets a little twisted, it's not like when you're a photographer for a wedding and you shoot the photographs at the wedding and you still technically own the copyrights and get to charge the wedding party an exorbitant fee. And I don't know, that maybe that's unfair. You did a lot of work. I just mean that instead of making it about the legal ownership of the copyrights, maybe you just charge them the proper fees up front. But I get it, you're separating, you're bundling and all that. Anyway, so let's start with the contract dispute. Let me first validate Alex, because I think this is very important to do. Alex is a human person, and if she has a real contract dispute with Imago Softworks, that sucks. And it's nothing to laugh at, and that's nothing to make light of. And she has all the rights in the world to go after Imago. And we're back. I don't know what that was. That might have been just a loose connection in between the DSLR and the Elgato camera capture device. Lots of cable wiggling seems to have fixed things. So I apologize for that. It should not happen again. I believe I've fixed the issue of the DSLR resetting every 30 minutes. It does not do so when I'm just capturing its HDMI out, and it only began to do so last time because it wasn't properly connected to USB. So I think it is now. So it hasn't gone out since an hour ago. This time it was the Elgato capture device, but again, I think it was a loose connection, a moose connection. Anyway, sorry about that. I will cut that out of the final video on demand, but thank you for bearing with me. I really appreciate it. So where were we? I was validating Alex. I was saying that contract disputes suck and you should go into... yeah, where was I actually? Chat, let me know, because I noticed only slightly after that happened. So let me start over. I do want to validate Alex as a human person. Contract disputes suck, and the proper remedy for that is to take your other party to court to either get an attorney and make some demands and hope that they give in, or take them straight to court. What's not proper then is what has happened afterwards. She has apparently asserted copyrights over these works and then asserted her copyrights to take down Let's Plays and live streamers and I guess other videos that have described, reviewed, whatever, contained her music within the larger, video game work that's being rebroadcast or reproduced. So that's not how copyright works, so I thought it would be a great opportunity to go over what's going on here. So now that that's out of the way, and it looks like my feed is still going, yes, the remedy is to sue to enforce contract. That sucks. So why would she shift the burden to Imago Softworks customers? I mean, that definitely seems like something you could do if... and I've definitely reveled in the schadenfreude in the past when, say, someone has hot linked to a photographer's image on their website and, say, ABC News or CBS or, I'm not saying they did it. I don't remember exactly who it was, but one of the larger news organizations was hot linking to the images so that when viewers would load the larger news organization's webpage, the images would load from the photographer's webpage, and they would get charged the bandwidth for it and not the larger news organization. Of course, all the photographer had to do was go and turn around and change the what the image that is contained at that link is, and the news organization was suddenly displaying something more graphic or inappropriate. That's not what I'm talking about here. This is more of a completely legal business arrangement that Alex seems to have gone around in order to get some sort of vengeance or extortion to fix this contract dispute. So I'm guessing that's what she's done is she's trying to issue these takedown notices in the hopes that this uproar will cause Imagos to then pay her to make the whole thing go away. That's not how this works, and we all know that that's not how this works. This is not a person who is properly using the law, and we're much more interested in people who improperly use the law than we have sympathy for people who are properly using the law sometimes, as cold and difficult as that is. Then there's this thing about she sells her music on Bandcamp and she's offering her music for sale for $1,000. I don't even know what that is. Somebody can post in chat your thoughts on what that is, and we can talk about that too. So, does she have a contract? Let's take a look. Not that. That. Let's take a look at the contract that I was sent. Supposedly a copy of her contract, her original contract with Imago Softworks, for the, well, they say film title, but it seems to be just a form document. So it's for Starmazer, and it's for March 1st, 2015, so a little over 2 years ago. She's the music director. I took the time to redact some things here, just to make sure that I didn't accidentally or unintentionally dox her. It is not my intention to bring any hate or violence or harassment back upon anyone. That is never the way to deal with any of this, and I don't think that there's really ever a justification for that unless it is the reasonable measure against violence itself. So, and there's this more. I can't get over this. I don't know why there's this Morse code here. BBBN, I think it is, or GGGN or something. I don't know what that is. That might just be just somebody's cute separator. So that's fine. Those are the parties, and it's for Starmazer, not Starmazer DSP, but that doesn't necessarily mean anything because it says here that the contractor shall render services hereunder from the start date, usual and customary services for a person employed in this capacity throughout the completion of the contractor's services as determined by production company. Services in the position stated shall be rendered to the best of contractor's ability, etc., etc., etc. That's pretty standard language and doesn't say only for Starmazer. Just because the work title up at the top was Starmazer does not mean that all work she does has to be for Starmazer and that they can never do work on anything else. This sounds like an ongoing kind of contract. There's more in here that doesn't really need to be gone over, but I will scroll through it quickly here. And then the term is what I want to get to. Unless expressly provided elsewhere in this agreement, contractor's employment hereunder shall not be for a run of the show or for any guaranteed period of employment. So this seems to be limiting the employment that it could be terminated at any time. Reserves the right to discharge contractor at any time, subject only to the obligation to pay the balance, etc., etc. So perhaps that's what happened. Perhaps they terminated her and she's saying they did not pay the balance. I don't know. That would be a detail I'd want to ask about. No use of alcohol or drugs during hours of employment. Thank you very much. That's a very nice way of phrasing that. Unfortunately, a lot of places still consider use of alcohol and drugs outside the hours of employment to be an infraction as well. Of course, there are some safety requirements for people who work with heavy equipment or driving and things like that. But work for hire. This is the important part. Contractors' services will be performed as specifically ordered or commissioned work made for hire. Production company shall own all results and proceeds of contractor services rendered hereunder in perpetuity to use for all purposes. So this is a blanket license. This is a blanket assignment, not a license, excuse me, a blanket assignment of all copyrights. This would already be the law in most places that a copyright made for hire would be owned by the people who had hired. But this is explicitly stating that the contractor is creating copyrights for the organization, and the organization owns those copyrights in perpetuity, which means forever. There are some limits on what forever means. Obviously, the copyrights expire at some point, and then the public domain owns them. So that's not perpetuity, but you say that in the agreement, and everyone understands that it's as long as you have the right to be able to do that, that's your right to do. So I don't think there's anything really else in here. We have some other standard contract language, like this is the entire agreement between the parties. That means that you can't bring other writings that were made before this agreement into this agreement and say that they modify this agreement. It can be modified after. Contracts can almost always be modified after they are made. But that phrase, by saying it's the entire agreement, that means that the agreement is the only binding agreement, and it will be the only piece of evidence allowed in order to Haiku Knives, thank you. I look like a slightly stressed Mr. Rogers explaining complex issues. Yes, here's why I'm slightly stressed. Because that issue with the thing happened twice. It happened once before I went live and I thought I fixed it, and now it happened again. And that just got my adrenaline pumping. So if I seem a little stressed, it's because I wasn't expecting my stream to go down and have to deal with that. So my apologies for that. That definitely got my adrenaline pumping. Okay, so back to my face. And my notes. So this pretty much means that she doesn't own a copyright to assert. Even if she did, let's just stop there for a moment. Even if she did own a copyright to assert, would it have been legal to issue takedowns as an extortion effort or a negotiation effort with Imago Softworks? Still no, that's still not allowed. That's still a misuse of copyright. She's supposed to be issuing takedowns if in the furtherance of the creation of useful works of art and science, in the furtherance of the goals of copyright. She's supposed to be taking down copyrighted works that are clearly infringing, ones that are doing legal Let's Plays that are allowed by Imago Softworks and by everyone else. They definitely fall under a weird gray area in fair use as to whether or not they're commentary or whether they're a republication, and we get into that. So yes, I can see the legal argument that if you do a Let's Play, you could be taken down, but Imagos doesn't do that. And so it wouldn't be right or legal for one of Imagos's rogue employees or contractors to then suddenly assert a right that Imagos doesn't want asserted. So that's also not going to be a correct application of any sort of copyright law. So even if she did own the copyrights, there's still a very strong legal argument that she cannot assert those rights this way. And then when you add in the evidence that she's only doing it in order to negotiate a contract dispute, that becomes a misuse of copyright. And we talked about that about a month or two ago in the wargaming thing. What happens when you misuse a copyright? You now have unclean hands. You are coming to the table. Your side is not is liable in the dispute. They are not clean from that liability in the dispute. And that means a judge could very possibly invalidate your right to enforce that copyright, especially in that way. If the contract was canceled and Imago didn't fulfill their end of the contract, is there still any way she'd own a copyright? Probably not. Let's get into that. That is actually the very next topic on my list. Well, actually, no. I'll you know what? Let me just copy paste this real quick, and I'll put this topic down below this. So the argument is that if they violated the contract, that there's no contract, and that she must own the copyrights to at least to her music, right? No, that's not how that works. If you make a contract with someone to produce music for their show, for their whatever, and you produce that music and you deliver it, and they produce the show and they deliver it, but they never pay you, you do not have the right to interfere with that show. That could be seen as interference of contract. That could be seen as your own kind of copyright infringement. It could be seen as extortion. You have rights, but your rights are only limited to enforcing your rights under the contract. A violation of contract does not automatically void a contract. And even then, if a violation of a contract could void a contract, it would usually only be voidable. You would have to go to court and assert that right and get that contract voided by order of court before you could assert a right like a copyright like this. Ultra vires outside your power, outside your rights. If you want to assert a copyright in a situation like this, Alex, you're going to have to go get an attorney and figure out what right you actually own and assert that. I don't think you own what you think you do. Andre Solazaro, thank you for the $2. Thank you for another awesome video. Really appreciate your donations. I saw there were one or two others up there that I missed, and I do really appreciate you. I was in the middle of basically crashing and burning for a moment there, so thank you. I appreciate it. Yes, so there's void and voidable things. What's an example? We went over some of these in law school. Most void contracts and voidable contracts are contracts of marriage, basically. When an underage person gets married, certain underage marriages can be completely void automatically, and certain underage marriages are voidable, where you have to go to a family court and have the court void the marriage, kind of like a divorce. I don't know too many commercial contracts that are automatically voided by any party's breach. And many attorneys, including myself, still include language, even if it's unnecessary, that says that the contract or any term of it does not void the whole contract, and any term that fails or anything like that it's only that term that fails and the contract survives. It's very rare that I think you'll find a contract these days that just completely voids if part of it fails. The only ones that I think today that happen besides the marriage example that I gave would be contracts for an illegal purpose. If I made a contract for prostitution or drugs or illegal guns or some other illegal purpose, I mean literally like a contract, and people have tried this, like trying to make a contract for sex or something like that. You can't enforce it. It's void. It's just not even enforceable. So that's the only kind that I know about. So what is the proper procedure for Alex to pursue her contract dispute? Well, I actually don't know where Imago Softworks is. I didn't miss something in my research. I forgot to look up where Imago Softworks is. Tell me. Because Alex would have to assert her right somewhere between where Imago Softworks is, their state or country, and where Alex is. If they are both here in eastern Pennsylvania, then they can file a dispute in local court, even small claims court, depending upon the amount in controversy. That's not really that hard. You put together your evidence, especially your contract, your evidence of the contract dispute, any breach or anything like that. You write it up in a basic complaint. If you don't know how to do that, and most people don't, then you either consult an attorney or do a heck of a lot of reading online, and then you'll realize why you consult an attorney. And then you file your complaint with the local county court, probably where Alex is located or where Alex worked or something where, again, you'd want to consult an attorney about how you get jurisdiction over the person, as that's a very complicated topic. I'll be doing a video on jurisdiction very shortly because in about a week I have to argue jurisdiction in open court, so that'll be fun. And if anyone wants to come watch me argue, you can come see that on July 3rd. So then you file your thing, and then the judge will schedule a hearing date, and you'll go to court, and you'll make your point, and they'll make their points, and the judge will adjudicate the dispute. And that's not that hard. And frankly, most judges in most circumstances will even give you your attorney's fees for having to have gone to court and asserted those legal rights that you probably shouldn't have had to assert if the contract dispute is that egregious. In other words, if you did all the work and they didn't pay you, that's a really easy one. And if I was a judge, I would give you your attorney's fees back. So you hire an attorney, you pay an attorney up front, you take this person to court, you win, you get your money, so you get your judgment, and then you pursue the money from the person, and you should be able to get all of your money back in the end, in theory. The actual act of collecting that, I get it, is more of a practical difficulty, but in most cases, you can eventually get it. You just have to keep pursuing it. I know that sucks, but that's also just something you're supposed to understand when you or get yourself into a contract or open yourself up to business in this business world. All's fair in love and war and business, apparently, sometimes. But not DMCA takedown notices. So if you then want to assert, like, you're not satisfied. Let's say you're Alex. You're not satisfied with the way that your dispute with Imago Softworks is, or Films, yeah, it is Softworks, is progressing. So then she apparently goes and issues several DMCA takedown notices, sometimes multiple notices to the same channel, asserting her right against the copyrights of the video that was produced. Now, anybody can do this. You, I, anybody can go write up a DMCA notice, send it to YouTube, and get a video taken down. In fact, I guess it's a miracle it doesn't happen more often. The idea or the deterrent is that someone has the right then to pursue you back. If you file a DMCA takedown notice and you're wrong, you could be pursued back in court for any of the damages. This could be a real problem if you are, say, Philip DeFranco or PewDiePie or Jim Sterling or H3H3 Productions. Taking down one of your videos could mean thousands to tens of thousands of dollars, could mean an upset sponsor who doesn't want to pay for sponsorship on a video that isn't airing, an upset sponsor who maybe wants another free plug in your next video, costing you another sponsorship. And so you're talking about anywhere from a few hundred to a few thousand to many, many thousands of dollars, depending upon what video is taken down and how popular it would have been. And you're talking about the difficulty of having to prove how many views would it have gotten. So you have to go back and show what other videos have got. And if you're not, like, what if it was your one viral video? Then you're screwed because you have no history to show. So it's a really kind of a scummy thing to use a DMCA takedown notice in this way. So there is a law, there is a deterrent, there is something, and hopefully this comes up properly. Nope, of course not. Hang on, we'll go back. I forgot to switch Chrome over to this. There we go. So there is a deterrent to help us out in case you have a problem. Someone files a false DMCA takedown notice on you. You have an entire statute that you can cite against them. Section 512 of the DMCA, Title 17 of the U.S. Code, Section 512, down to Section F, letter F as in Foxtrot. Oh yeah, somebody criticized me for using Frank instead of Foxtrot, and the reason is that Frank often sounds a lot more familiar to people who aren't familiar with the phonetic alphabet, and I've had people miswrite Foxtrot as FT, so I didn't. I have to correct myself on that, but yeah, F as in Frank, F as in Fox. Danny Baverstock, £4, thank you. Nothing to say other than thank you. I appreciate it. Okay, so if you've had a problem with a copyright strike or a copyright takedown, doesn't need to be on YouTube, can be any copyright takedown in the U.S. If you're not in the U.S., you either have to be then find a way to get yourself into U.S. jurisdiction for your case. In other words, find the minimum context necessary. You'll have to talk to an attorney about jurisdiction. Or use your country's law, which should have something similar, a legal right or procedure for someone who takes down your videos should be there should be some kind of claim you can make. In the United States, under 512F, anyone who knowingly materially misrepresents under this section that material or activity is infringing, or that material or activity was removed or disabled by mistake, shall be liable for damages, including costs and attorney's fees. Or by a service provider who is injured, or as a result of the service provider relying. Okay, so it applies to service providers as well. We'll skip that part because we're not talking about service providers. And hey, guess what? There was a case on this. And you may remember Lentz v. Universal, a case in the Ninth Circuit, I believe, that finished up last year and said that there was a right to fair use, that you have a right to fair use, and that anyone who takes down your material has to have conducted a subjective fair use analysis. Well, would you believe it? Lentz v. Universal got appealed to the Supreme Court, and something very interesting happened. Well, let me skip that. The Supreme Court denied certiorari. What the heck is that? Let me bring it up on the screen here. The Supreme Court, here's the list for June 19th. They did some interesting things this day. We're going to skip those, but the one that's most important here, Stephanie Lentz v. Universal Music, certiorari denied. What does that mean? Jesper N., thank you for the Denmark Danish kroner. Is that what that is? Thank you. Oh, you even said it. 20 Danish kroner. Thank you, Delby, for the 500. What is that? Yeah, euros or francs? Is that euros? Holy crap. Thank you so very, very much. And Timothy Riggs, thank you for the $2. Any chance for a recap of those of us just joining? Yes. And I'm still a little floored by Delib. The 500 is amazing. I think that's euros. Holy crap. Okay, and we're still, okay, and everything's still good there with the audio. Wow. $560. Holy mackerel. Thank you for the blessing. That is extremely generous and very helpful. I've been trying to up my video production for the past week or two. I did take a little bit of time off in the beginning of June, sort of unexpectedly, but so this is going to really help that. Where the heck were we? You totally stunned me. Somebody asked a good question. Quick recap. Yeah, let's do a quick recap. So where are we? Alex Maurer is a music director, composer for Starmazer, a game made by Imagos Softworks. After an alleged contract dispute, she issued multiple DMCA takedown notices for people who had used Let's Plays or footage of Starmazer and Starmazer DSP. We're discussing whether or not she's done that as a form of extortion to negotiate with Imagos Softworks, or whether she actually owns a copyright that she should assert. And so far, I'm concluding that she does not own a copyright that she can assert. We are discussing whether fair use is still a valid right in this country, or whether the Supreme Court has ruled on that. The Supreme Court has... Where am I? Okay. The Supreme Court has denied certification, certiorari it's called. We use the term of art in law, certiorari, because that one word means this one thing, and we can count on that. But in the real world, in the practical world, what certiorari means is just certification. It has not been certified to the Supreme Court, and you need to know what that is, or it doesn't mean anything to you. It means the justices met. They looked at this case. Not necessarily met. I mean, they looked at the case. They may have met. Jay Valentine. I will try to read that in a moment. And they decided that the case did not merit their further review. Unfortunately, that does not mean that they have created any precedential law. Instead, what they've done is said, we don't see any reason for us to review this. We think this case is fine the way it is, but we're not going to take it any further than this. So that means that Lentz is still good law in the Ninth Circuit and is still very persuasive law everywhere else, and should be pretty much good law everywhere else, but there is a possibility that another circuit could rule differently, and then we would have a circuit split, and then we would have more of a reason for a case to go to the Supreme Court. Lentz had been appealed not by Universal, but by Lentz, rather her attorney, because they didn't feel that a subjective fair use right was enough, and they wanted the Supreme Court to affirm an objective fair use right. The difference is a subjective fair use right means I have tried to make my best determination that I think you were not using my material as a fair use. Objective means I have to be right about that. By the standards, by the legal standards. Subjective means I have to show a good faith effort to meet the legal standard, but that I still felt that I genuinely, sincerely felt that it was infringement, or felt that I was right in what I was doing. Objective means I can think all I want, but I have to be right about it in the end. If I'm wrong, then I have to pay for it, basically. So this difference means that if you are wrong about it under the subjective standard, if Alex genuinely thought she had a fair use right, and she can go to court and prove that she did a fair use analysis on these things and came to a genuinely earnest conclusion, wrong as it may be, that she owns a copyright in Starmazer, then she may actually not be pursuable in court. Or rather, you could win a judgment, and the judgment would be for a minimal amount of money. If you can prove in court that she intentionally used used these DMCA takedown notices, knowing that she was violating copyright, should have known that she was violating copyright, willfully knew that she would be violating copyright, willfully ignorant of her fair use standard and obligations and all that, then that means that you can get your costs and damages back from her under the DMCA section 512F here, under this part that says shall be liable for any damages, including costs and attorney's fees incurred by the alleged infringer. So To me, that means that she doesn't have a leg to stand on in court. IMHO. Again, this is just my professional opinion. This is not legal advice. No one should go sue her without doing their own research and consulting their own attorney. So, that said, I'm offering my services as an attorney. She's apparently in somewhere in Washington Crossing, Pennsylvania. If she's still in Pennsylvania, I'm in Pennsylvania, only about an hour north of there. I have a local federal courthouse next to me, only about 5 blocks away, where I can file if I have to. Most things are done electronically now, but if there's hearings or whatever, there's also a court in Philadelphia, which is only an hour and a half away from me. So if anyone needs representation, or if anyone has an attorney who needs local counsel for pursuing Ms. Maurer, I'm offering my services. And contact me offline. You'll be able to search for my name and find contact information everywhere. How would that play out? How do I think we would go about that? Well, one, I don't think she owns a copyright at all, so we assert this 512F misrepresentation. Two, I think that this is some kind of extortion or fraud or misrepresentation under many other laws. Local laws, state laws, there's probably even a few federal laws that she's violated. So basically, we hit her with all of that. And I have a feeling that you'll get your damages back. You'll get your message sent. You may be able to get an apology or some other kind of relief, depending upon what you're looking for. And you'll probably have the proper deterrent effect that we need. The problem with all of this is it sounds great to talk about, and SidAlpha made a video, and Jim Sterling made a video, and TotalBiscuit made a video, and now I'm having a live stream on it, and everybody's having a great time talking about it, but someone has to actually pursue her, or else nothing happens, because there isn't a criminal statute for this. Yes, copyright infringement is a crime. The FBI does not pursue people for an illegal takedown on YouTube. When someone hears about that, someone tell me. I'll be very surprised. Blue Bee, $5. You are a great and interesting lawyer. In time, might make more from YouTube than being a lawyer. Sometimes that is true. Thursday's show was much bigger than I thought it would be, and I am most humbled and most grateful to all of you for your support, your viewership, and participation. This is absolutely amazing. As I said on Twitter, this is like a spark to kindling. Every single one of these legal issues is like a spark to kindling around here. And holy crap, as long as you guys wanna keep having these fires, I'll keep stacking the kindling, and we can keep letting them spark it. Anyway, could it be a class action? Sort of. Yes, class actions are useful for these sorts of things, and it's just does it reach the level of class action? And I think it might. I'm not a very experienced attorney when it comes to class actions, and we didn't discuss them a whole lot in law school, so I would actually have to do my research on that. But my understanding is that we would probably need a larger firm than just me, because a class action, the court has to certify that the firm has the capability and experience and has done class actions before. I certainly do not. So I would certainly love to be part of a class action. So if there are any attorneys out there with experience in class actions and this sounds good to you, I will be happy to be your local counsel. Please give me a call, preferably tomorrow. Or after tomorrow, after today. Oh yeah, okay. No, wow, we went over everything already. Extortion, coercion. This could also be considered defamation. She has issued these statements claiming that these things were in violation of copyright. That's pretty much a public statement, and it's most definitely become a public statement now. So. Not as strong, but if we can connect the dots through legal research and practical research, it may be possible to assert that she has defamed Imagos and these channels by asserting a copyright that she does not own. Tom Resnick, thank you for doing what you do, Leonard. Parting the legal fog concisely and charismatically. Fascinating, much appreciated. Thank you, Tom. Very much appreciated back. Malik, 1013. TotalBiscuit's video has stated that the DMCA takedown on YouTube is not a formal DMCA takedown, but merely on the guidelines and hence not subject to perjury. I would still argue that it's a misrepresentation under the section. YouTube is still following the safe harbor provisions in the DMCA, and therefore is still they're still doing it under this law. Because if they went outside of this law, they no longer have a safe harbor. And now I can sue YouTube for obeying her DMCA when they knew it was illegal, or should have known, especially now that we've all reported it to them so many times. So if YouTube's process is somehow not a real DMCA process, I don't think so. It may not. I need to see the details there. They have an obligation under the thing to follow the takedown procedure. So this is just the way they've implemented it. They've implemented it within their discretion. They're given the discretion within the law as to how to follow it, and then they just have to be able to go to court and say, here's what we've done to follow the law, that they are compliant. So their DMCA process is compliance with the law. I don't necessarily agree with TotalBiscuit that it's not an actual DMCA process and therefore couldn't subject her to liability. We could find that out. I don't think so. That was certainly not an argument the last time I was in court on this exact issue. I have been in court and I have won on the DMCA 512F issue. Now, you may or may not like that I was probably on Alex's side of that one, but the plaintiff, or excuse me, should I say the defendant in that one, I'm not going to talk about the actual details, but the defendant in that one genuinely had asserted a sincere belief in copyright, and when confronted with the facts that the fair use analysis had been objectively incorrect, immediately my client removed their DMCA takedown notice, unlike this case. So unfortunately, my client was still pursued into court, and that did not reach the level of a DMCA misrepresentation. So I guess I'm also saying that I know exactly what a court around here is looking for when it comes to a DMCA misrepresentation, and this is damn close to it, if not well over the line. And I think in discovery, we would find out exactly what the motivation was behind all of this. And I have my serious doubts that there is a genuine defense to all of this misbehavior. Oh yeah, Yoshi, thank you. I totally forgot that I had a back channel here. So we're getting to be a real show, guys, and I now have staff who are feeding me things from behind the scenes, and Yoshi has sent to me a copy of a, let's see if I can bring this up on the screen. Open original, and go to Chrome. And yes, it's a little bit off because I have it set for, we'll center it here. So this appears to be a real DMCA takedown form from YouTube. To submit a DMCA complaint, please complete the following fields. And it does. So it says DMCA, and therefore I believe it is fully compliant with the DMCA, and therefore there's really no argument to make that it's not a official DMCA legal process. No, that's not pretty. I'm not doing that. Here, we'll put it back like this. Is that better? Okay. Where am I on my outline? Holy crap, I'm done. Questions? Let me take a few minutes and interact with you guys in chat here. I apparently got through that much quicker than I anticipated. It felt like I was going really fast, but I've been talking for almost 48 minutes, aside from the crash and burn we had there. Yoshi, if you would like to feed me any questions, that if you've been capturing any. Dave Camboy says something about desync. Are we good? What about Alex's Bandcamp? If she doesn't own the copyright for the music, can she seek damage? Can Imago seek damages? What is Alex's Bandcamp? I tried to visit it yesterday and it was down. I guess I would need to know what music she had up there. If it's the music that she wrote for Imagos, then yes, she is also how do I activate slow mode? She is also in violation of copyright then, because she should not be selling music that she has already assigned a copyright for. How do I activate slow mode? I think I have to go to the settings here. Enable slow mode. Oh, crap. Sorry, slow mode was supposed to be on. Is the audio off? Is the audio late or is the audio early, Blue Bee? I actually have been trying so hard to work on this syncing, and I thought I had it. Ah, yes, the Bandcamp should have been taken down if it was for music from Imagos. So they DMCA'd her back. That's awesome. Okay, don't adjust the audio. Thank you. Yeah, it's difficult. The audio seems to come out of the camera synced to the video, but then somewhere between the Elgato capture device, OBS, my internet connection, and getting to YouTube and then getting processed and everything, it somehow desyncs just a little bit. And so I've been working on that. I currently have it set. Audio is fine. Okay, thank you, Brandon. What happens in case she or he decides to drag this more? Can the affected YouTubers try to sue for damages and loss of revenue? Yes. The only trouble is that you do have to prove your actual damages. So no one's going to get rich off of Alex. First, let's consider that no one's going to get rich off of Alex because most people probably don't have a terribly large claim. If she took down a PewDiePie video, sure. If she took down a Leonard French video, maybe she's liable to me for a couple $100. If she took down a video that got 10 views, your probably best bet is that she'd be liable for your attorney's fees, so you might be able to find an attorney that would work for you for free or for low cost in order to recuperate the fees later. And even then, courts limit that, so your attorney can't just work for free and then give Alex a great big bill. Your attorney has to work for pay and then give Alex the great big bill. So it's a difficult situation there, I understand. No one's allowed to profit from it though, so you're not going to win any windfall or extra money or anything like that. If you win in court and it's a open and shut, black and white, slam dunk victory, you're still only going to get your actual damages that you could prove in court. What do you think of Alex's claim that she would rescind the DMCA claim if the YouTuber involved complained to Lagos? I think that actually furthers my opinion that this is illegal extortion using copyright, using the DMCA claims, and that her request can and will be used against her as evidence in a court of law. Can't she just be licensing music? We don't think we know. I don't think we know the actual contract content. If so, doesn't failure to pay imply a lack of rights? Yes, if there is somehow some governing contract that is other than this one that I've been given, if she has a separate contract and that contract says that Imagos is only licensing the music and the license is only valid upon pay, upon her receipt of pay, then yes, it could technically be them violating that license or them violating Okay, round 3. That again was the capture card. The camera's still going. Camera's fine. Okay. Can't she just be licensing music? We were there. Again, it's the same problem with licensing as any other contract. If Imagos has not paid, then they're in violation of the contract. If Alex somehow has a clause in a written license that says that Imagos doesn't own the license until they pay, which would be understandable. I have that clause in my representation agreements. That still doesn't mean that she has the right to go after Imagos' customers. It would be very complicated because the Ghost customers would be pulling everybody into a very complicated lawsuit in that case. But it's still, oh yes, it's very possible for Imago to take her to court. It's still not asserting her right against the proper party. She's asserting her licensing dispute against Imagos against Imagos customers instead. So that seems to me like interference with the rights of the customers, and that also opens her up to legal claims. Can the developers of the game claim damages against her from the takedown and potential marketing, etc.? Yes, absolutely. They would probably be actual damages again. They would have to prove what damages they suffered. Does YouTube Google have any responsibility here for allowing this so easily? Probably not. It's working as intended. This is how the law is written, and they have spent countless hours, I'm sure. Well, I'm sure they've counted them because they've paid for them. But they have spent countless hours refining this system to be compliant with the DMCA. I am pretty sure, I don't remember the cases off the top of my head, but I'm pretty sure there were cases where YouTube and Google have been sued and have had to show that they are compliant with the DMCA and safely in their safe harbor. Leonard, are you going to interview Alex? No. Alex is potentially an adverse party, and I am interested in representing those who want to pursue her, and it would be inappropriate for me to contact her mostly immorally. I personally find it inappropriate. There are ethical rules that govern my contact with an unrepresented party, but I can follow those rules and contact her. I'm just doing her the favor of not letting me use things against her. If she talked to me, I would most definitely be trying to get her to admit things, and not in some obvious way. I would be very tactful about it and hope that she would open up to me and tell me things that I could then use against her in court. And I think we should avoid all of that. That sounds a little bit unfair to me. Totally legal, but a little bit unfair. So, why is everyone calling him a her? I didn't want to completely avoid this topic. I don't know what Alex's gender status is, but everyone has been calling her a her, so I am sticking with that. I do respect transgender rights, and I don't have any trouble with that. I don't think any of this dispute has anything to do with her status or her gender or anything like that. My only issue that I think that might come into this is that I wonder what, because I know a lot of transgender people have suffered a lot of discrimination. I wonder how she has suffered that, and if this lashing out is possibly amplified by her other experiences in life. And I don't mean any of that in a discounting or derogatory way. In fact, quite the opposite. I mean it in a very validating way. Lots of people, including myself, have had unique experiences, and if her unique experience has made her sensitive to these kinds of disputes, and she feels like she's being taken advantage of, and no one's helping her, and she needs money or just wants this contract to be fulfilled or doesn't understand what's going, she could be very frustrated, and that could be exacerbated by her unique experiences in life. And so I don't think it's appropriate to pursue her in any other way than the legal, natural consequences of her actions. And so I am all gung-ho about going to court against the DMCA and the contract and everything like that, and I'm going to stop any And I'm going to affirmatively request that no one try to contact her, at least not disrespectfully or angrily or anything like that. If anyone is trying to contact her, I hope it's for a legitimate journalistic purpose or to legitimately offer advice or help and not to harass, stalk, intimidate. Let the legal community intimidate her by helping us fund a lawsuit against her and these illegitimate claims, and not anything further. Sorry. Have you read Imagos' reply on their Kickstarter? Brandon, can you post a link? And I will. I'll do it right now on stream. Isn't extortion criminal? Mark, yes, there are criminal laws, crimes on the books for these kinds of things. This is not reaching the level where I think a state or federal government will pursue. Can a person make a private criminal complaint in Pennsylvania? Yes. You can contact your local district attorney. If you are a Pennsylvania citizen and you have been wronged by this person, you can make a private criminal complaint and claim that you feel like you've been extorted. I don't know that that's extortion. I don't know if you, the third party who owns the copyright on the video that was taken down, has an extortion claim against Alex. She didn't extort you, she extorted Imago Softworks. I guess your argument for extortion would be that she extorted you to contact Imago Softworks. As benign as that may sound, it is still an extortion. So yeah, that would be... And you could see why maybe a DA is not going to pursue that. It's a kind of a smaller thing that could easily be resolved in local court. Okay, Imago Softworks. March 12th. I've had a very difficult time. The best approach to publicity issues, which has happened with Alex and Imagos. I have been as measured and responsive as I can without responding to the situation in a rash or defensive manner on social media. At this point, I feel it is important for me to make one statement, the statement offering some balance. In short, Imagos and Alex entered into a for-hire contract for Starmazer and DSP and a number of other projects. At some point last year, Alex experienced some medical issues that slowed or halted progress on these items. Imagos fulfilled our side of the agreement in that we paid for work received and in some cases paid in good faith for work that was not received. Alex left the team officially in the middle of last year, citing the health issues and desire to refocus her life. It may be related to those other experiences that we talked about. In Alex's time since leaving the team, she has made claims for outstanding pay, the amount of which has fluctuated. Imagos has made several attempts to broker an amicable deal with Alex, including offering shared universal rights to the DSP soundtrack, as well as an equity share of the game's revenue. We have done this in good faith and an understanding of Alex's health concerns. At one point, an agreement was proposed and agreed to, but later dissolved. 2 weeks later, Alex issued a DMCA takedown request to Valve, forcing DSP's early access release to be temporarily suspended during the investigation. Imagos filed a counterclaim, and Alex was asked to provide proof of a rights chain violation. She did not do so. Proof of copyright and correct chain of rights has been provided by Starmazer DSP and was unsuspended. Imagos was left with no choice but to seek counsel to protect our team and the interests of we who have poured our hearts and souls into this game. Alex's claim has shifted radically over time from not being paid for time worked to not being paid for the right project, to the supposition that there was a plot to defraud her from the very beginning to the project, to a handful of other variations of the narrative. Oh, I'm so sorry. This sounds like a person who is going through a mental illness period. And that just makes this all that much more complicated because I just feel bad now. Of course, you still can't abide. The dude cannot abide. Your favorite copyright attorney cannot abide. And the most recent version describes a scenario in which our contract did not include or encompass Starmazer DSP, which is at odds with Alex's base claim that she has not been paid the amount under her contract for DSP. In the end, the facts at hand are Imagos had an ongoing work-for-hire agreement with Alex Excuse me. True. Rendering her paid for work the property of Imagos. Imagos holds an actual copyright on all materials related to DSP. Alex was paid approximately $36,500 for her work with Imagos. Imagos has no desire and has taken no action to commit rights violations against anyone. Imagos has made several attempts to reach a favorable resolution with Alex, both informally and formally, by registered letter and communication. Alex has also attempted to release an album on Bandcamp containing the Starmazer DSP tracks, along with material suggesting that her fans boycott the game. She has threatened to do so to both Imagos and our publisher, Playism, if her monetary demands are not met. Wow. This person has some narcissism or ego issues going on here. This is way outside of the bounds of common human decency. When met with our extensive log of data refuting Alex's allegations as well as our registered copyright and DMCA claim, Bandcamp removed the album. In response to this, Alex has posted the soundtrack to her personal website with the same inflammatory statements she'd threatened to and eventually released on Bandcamp. Though it is within our rights to issue a request for her ISP for removal of the soundtrack, I do not feel this is the correct course of action. I do not intend to fight a grand battle with Alex, and I've decided instead to release our claim to the music's rights in effort to ablate the issue and restore some semblance of personal emotional equity. I have offered by official letter to release the rights in exchange for Alex's agreement to remove her disparaging claim. She has declined this option. The tracks made by Starmazer DSP have been removed from the game and replaced with temporary tracks while our new music partner composes an entirely new soundtrack. My offers to Alex for rights to this music still stand. And it is my desire that this situation be resolved amicably, and it is my sincere hope and has always been that Alex can find some peace and security. This has been a personal nightmare. DSP is still in very active development. We have targeted a summer release. Official release date announcement are complicated. It will be announced as soon as yada yada yada. Still in very active development. We have partnered with Arcade High for the core composition, etc. Don Thacker, Star Commander. Don, I admire you. That was well written. That was fair to Alex and not over the top, and it really sounds like you've tried to work this out. So here this sheds some light on why Alex may think that she has a claim to the rights for the music, in that Starmazer, Imago Softworks have agreed to release the rights to the music. It does appear, though, that she has denied. She has not performed the contract. She has not released all of the claims that she has against Imago Softworks in return for them releasing the rights. So if that's the case, then she still doesn't even have a claim to the music. Now, that makes it kind of complicated. If she does have a claim to the music now, and people have posted Let's Plays and reviews of early access of Starmazer, and it contained her music, you definitely have a more complicated case in a court of law, but I still do not think that you have a bad case at all. You're not making the case that you or Imagos own the copyright. You're making the case that you used this footage and the underlying soundtrack as either a fair use or with an implied license or with equitable reliance, like we just discussed in the last video. Or in the GTA 5 video, not my last live stream. So I still think that people who have received DMCA claims have very good cases against Alex, and anyone who has lost any significant amount of money or who has the resources to pursue Alex should be doing so. And if you would like to join forces to do a Kickstarter or GoFundMe or Indiegogo or whatever the appropriate crowdfunding campaign is to pursue Alex, I would be happy to help you with that. I will stop short of personally trying to start such an effort. It is prudent and moral and ethical for attorneys to assist clients, not causes, as one of my mentors would say, and it starts to cross the ethical line if I'm trying to pursue my agenda by finding clients that have the case that I want. And although I don't think that that's necessarily wrong or inherently unethical, it's just starting to get closer to the line, and I would prefer to find clients who have genuine claims, and I'll pursue their genuine claims and their desired outcomes rather than mine, which I think is the most appropriate way to handle these kinds of cases. Are we doing okay, chat? What's going on, Cerulean? Oh, I see what happened. Nice. You accidentally unbanned the same person. I have no idea what her claims against Turner Broadcasting would be, Jason Del Gaizo. What claims did she make against Turner? Can someone tell me? Oh, okay. She has a cease and desist against Turner Broadcasting for Duck Game. I have no idea. Why would she have a cease and desist against Turner Broadcasting for Duck Game? Did she do the music for Duck Game? Okay, here we go. Let me see if I can bring this up. Let me adjust this. I'm just gonna kill chat for a stop. Just the. Where is it? Okay. There we go. She has just emailed me this, a cease and desist letter to Turner Broadcasting. What? Oh, God. All right, let's go over this now. I thought we were done, Alex. I thought we were done. But you keep coming back. No, I'm kidding. Okay, 6/21/2017. Turner headquarters. Improper use and infringement of Alex Maurer's copyrights. Preservation of evidence demand. Okay. This is how I start some of my lawsuits as well. It has come to my attention that you are using Alex Maurer's proprietary copyrighted material. Ms. Maurer is owning the copyrights. Does she want to tell us? No, of course. Wait, no, it's under copyright.gov. Sorry. Where am I? Nope, that's not the search part. Oh, it's right here in front of my face. I don't know. Am I doing this right? Can someone verify that that's the number, right? U.S. Copyright Office's registration number. Yeah, nothing's coming up. I'm either doing it wrong or something. Okay, yeah, Yoshi, tell me if I'm doing this wrong. Because I'm not seeing this. But okay, let's go back. Your unauthorized use of the copyrighted material gives rise to copyright infringement. If you do not promptly comply with this demands, reserves the right to pursue claims against you without limitation, copyright infringement, unfair competition by misappropriation, violations of other common law, statutory, and intellectual property rights. Sincerely, Trademark Engine on behalf of Alex Maurer. Who the heck is Trademark Engine? I'm guessing she's used a website called Trademark Engine to file a cease and desist letter, or to send a cease and desist letter. Best guess. Okay. I don't think that's anything terribly remarkable. That just sounds like more of the same. It's interesting in the sense, I don't know why she's doing it. What the heck does she claim to have? Did Imagos... Somebody answer me. Did Imagos work on Duck Game? Did she work on Duck Game? And I don't know. This could also be something separate. Perhaps she thinks that she has some kind of music in Duck Game, or she found her music in Duck Game or something. I don't know. Spike Viper, thank you for the $10. People like you helping the YouTube community together. We can all agree that fair use is one of the largest problems facing us YouTubers. Yep. But as Buddhist teacher Eckhart Tolle likes to say, and I'm sure he's quoting many other Buddhist teachers, the obstacle in the way is the way. In other words, if you have something in your way and you're getting all frustrated about it, remind yourself that it's in your way, therefore it is the way. There is no way going forward that does not include that obstacle, so you might as well stop looking at it as an obstacle and start looking at it as the path. And I know that is sometimes a difficult practicality to accept, but believe you me, you will find yourself a much healthier frame of mind when you can properly frame the difficulties in your life the right way. Backsorn, thank you very much for the $5. Is this Alex's attempt to copy-paste a legal document and say, hey, this applies to you too? Yes, it sounds like it. Trademark Engine, I don't know what they do. It seems like they enforce trademarks or help you file trademarks and such, so it looks like maybe she used a form document from there. As far as Jinzo Defiler knows, she did the music on the trailer for Duck Game. Okay, that's great. Did she not get paid for Duck Game? I don't know. That's pretty stupid. So I don't see what kind of claim she has on Duck Game, but again, I don't know anything about that, so we'll have to see what she has to say. Will I be able to inform you if I represent someone in the case? Yes and no. If I'm given permission to inform you if I represent somebody, we can talk about it. Heck, if my client wants to make a whole video series about it, we can do whatever you want. If most of the time, attorneys, including me, will limit what we say during a case because anything that we say could be used against us in the case. So once I have information that could be confidential, I'll probably not talk about it until it's been revealed publicly in the case. And even then, I'll limit how much I speak about it to how much my client wants me to speak about it. You'll notice a complete change in tone in me on this one if I am not allowed to speak about the case. I just simply won't be speaking about the case, and when someone asks me, I'll have to say, I'm sorry, I can't comment on that. So consider this the canary. If her copyright dispute with Imagos is settled in her favor, what are the chances that she will still keep the DMCA takedowns on those channels? Well, hopefully she'll release the takedowns if she gets what she wants, that is favorable resolution with Imagos. But let's go back to that letter that the what's his face, I think it was Don from Starmazer wrote. If he assigns her copyrights, if they say, fine, we're not going to use your music, and here are your copyrights, and now she really does legitimately own the copyrights, she still owns them only from now forward. She doesn't have a claim to the copyrights from before. She only has a claim now. So those people still relied on either their express or implied license, or operating under fair use, or Imagos, or excuse me, Alex is equitably estopped from etc. All those same copyright arguments that we made the last 2 videos or so would apply to this scenario, even if she gets the copyrights now. Hey, TotalBiscuit, I am honored and humbled that you would join us in chat. That is really cool. Hope you're having a great Sunday. Love your videos, and keep doing what you do. But I don't think I need to tell you that. Anyway, didn't have to leave. The agreement that Leonard showed said they agreed to $40K in payment. Star says they paid $36.5. Is the 3.5 the contention? Could you please ask Leonard? If that's the case, that sounds like that's the case, that they paid her $36.5 and she was due $40. That's again, that's not enough. That's not enough to say that they didn't perform under the contract and that somehow the contract is void and that somehow she automatically owns the copyright. She would have to go to court, get some kind of judgment, and that judgment would have to contain an order assigning her the copyrights back, which would not really happen. A judge would give her the money, not the copyrights. She's due 3.5, possibly plus any compensation for her damages for having to pursue the 3.5, including attorney's fees, interests, costs, travel, things like that. Reasonable travel, not like first class. But the most she could do is get that back, not get the copyrights back, unless she could also somehow prove something else, that there's a separate license or separate agreement that we're not seeing that has some very tailored special clause in it that says that she automatically, I could write it, an attorney could definitely create that clause. I just don't see that clause ever, or as having been written into these agreements, or as operating in this situation. So yeah. Whew. Okay, I am going to start winding this down. If there are any more questions, now would be a good time to ask, because I'll probably be having only a few more minutes of stream. I'm going to try and start some music here, and we'll see if this works. Shoot, I don't remember which one it was. I'm going to mute myself for a second so I can start the music. Okay, I put some quiet music on in the background. Let me know if that is too loud, because then I'll bring it up later when I bring the doggos back and close my mic and close the stream. If it's annoying, I've never done it before, so if it's annoying, let me know and we'll never do it again. John Doe, you asked a question via Super Chat. I will go back and try to find it. Yoshi, go back and try to find it if you can. Euphorian Tremedy, do you think it's likely she ramped up ridiculous actions after realizing she could be in trouble to try and juke any legal action? Mental breakdown. Not really. I've seen people double down on the mental stuff before. It's not ever worked out very well. That's usually a misguided attempt. I can't go any further back up in Super Chat, John Doe, so I do thank you for your donation, but apparently I missed it. Could you resend the question that you had there? You don't hear any music. That's probably because I have it down too low. Okay, music is perfect, then I won't turn it back up. Okay. Leonard, have you discussed the update about the Rockstar and Take-Two case? Yes. No, I haven't. I intend to. We discussed it a little bit yesterday. The update is that apparently Rockstar has gotten through to Take-Two and issued all of the guidelines that I expected them to issue, and apparently Open 4 is back already, if I understand correctly, and will continue, and mods will continue, and now I guess I just want to see what's going to happen to the rating on Steam, since it got down into the negatives. TotalBiscuit, thanks for the info on the DMCA. Back when we dealt with fund creators in 2012, we were advised when considering perjury charges that the YouTube takedown might not consider a proper implementation of the DMCA. $20 from TotalBiscuit. Thank you very much, sir. Appreciate that. Yes, it's... I could see the argument, but I have serious doubts that it would hold up in court that it's not a proper implementation of the DMCA. That would subject them to not safe harbor, and they would be outside their safe harbor. They'd be liable for or they'd be open, they'd be risk. They'd be open to damages. Mr. Boutsky, €2. Can you speak about the H3 Productions case? I am so sorry. I can. There is no H3 update yet. Sorry. You know what? I will check on stream right now for you. Let me just log in, and then I'll bring up the... that way you don't see my login. So here is the Southern District of New York's website. It's very responsive today because no one's on it. And you can see from this, it says the date of last filing. Sorry, I have a filter on this real quick so you can see the top here. Now what happened? There we go. Now it's back. I don't know what happened there. Sorry. So you can see the top. It is Hoshenzada. How do you pronounce that? V. Klein, Catherine B. Forrest, and you can see that there's been no news since the 17th. So I do apologize for whatever that's worth, but Judge Forrest is still doing what she does. Do you think it's likely? Yeah. Yes, thank you. Okay, so I think that's all I have. Hypergrip says, people seem to be in two minds about Lens v. Universal. From fair use is now a right to it doesn't really force anything. What's your take on it? I think that I understand that no one has seen it used yet, so let's let Lens v. Universal get used a few times for what it stands for and have a few circuits uphold its ruling, and I'll bet you'll see people changing their minds. Some have said it doesn't really force anything because it doesn't change much. The standard always was subjective, that the potential plaintiff had to have a subjective good faith belief in their finding of not fair use, and all Lens says is that that is absolutely true. Both directions. Not only does the plaintiff have to have a subjective good faith belief, but the defendant can pursue them for not having a good subjective good faith belief. So it is toothless in the sense that it's not an objective belief. You don't have to be right about it, but the law is written that way. There wouldn't be language in there about the knowing material misrepresentation unless it was a subjective good faith belief, in my humble opinion. A DMCA claim filed by somebody who did not own the rights as per the court case would be invalid, and should be, yes. It would be a misuse of legal process, and that would be another legal claim that you could make as a plaintiff against Alex, would be misuse of a legal process. There's probably local, state, and federal laws against that. Is Lens Universal actually binding precedent anywhere outside the Ninth Circuit? Does it even matter elsewhere in the country? Yes and no. Your question identifies correctly that there is something there. It is still somewhat binding. I will stop short of using the word binding and say it is very persuasive. Other other justices will have to deal with Lentz v. Universal, or should I say justices in other circuits will have to deal with Lentz v. Universal by either agreeing with it or explaining why they think it's wrong. And the only way that it's not going to become binding law is if they can really explain why they think it's wrong. And there's honestly nothing wrong with it, from my opinion, from my perspective. It does not go too far. It correctly interprets the statute, and I really do not think that there's any reason it could be overturned. So I find it to be, and I would advise clients and potential plaintiffs to treat it as if it is good law in all of the circuits, because attorneys like me will be pursuing it as though it is, because it seems like a very, very firm foundation for that belief. Balthazar Plays, $10 Canadian, entertaining and informative human lawyer. Much respect for people like you. Kudos. Thank you very much. I have a lot of respect for all of you guys too. It is absolutely amazing that we have such a wonderful, productive discussion about the law on this channel. Lucas Baranski, Polish dinar, is that what that is? YouTube community benefits from your work. Keep doing what you do. Greetings from Poland. All right. This has been fun. Let me see if I can find the dogs. A head popped up. I have treats. I have treats. Come here. Can you come up? Can you come up, say hi? Can you come up, say hi? Can you come up? Come on. Good girl. How are you? Stay here for a second. Say hi. Can you stay here and say hi? Hey, let me pick you up. Let me pick you up. I know you don't always like this, so we'll only do it for a moment. So here is Ilsa. This is my 85-pound German Shepherd, Ilsa, and she is my big protector. She loves to protect me and chase the ball. And those are about the only things that she does. Oh, and the airsoft BBs. She loves to chase airsoft BBs, and when I knock over the target, she goes and retrieves them. Even though I need the targets down by the target, she comes and brings them back. Thank you, Ilsa. And here's another treat for you. Nico, come here. Nico. Good boy. And here's Nico. This is my therapy dog. Unofficial therapy dog. Because everybody needs a little therapy. Oh, he's looking at the treats. Here, have the treats, and you can stop looking at them. Here, look at the camera. Hello. Hello. Oh, thank you, everyone. Thank you for your $5. Rizik, and there was someone I missed. I'm so sorry. Thank you all. Thank you, TotalBiscuit, for the dog money. Oh yeah, I'll go get them awesome bones. How about that? Awesome bones afterwards. We'll post pictures to Twitter. We'll go to the pet store. Because it's a very nice day outside here, and that's why I did the live stream early, so I could talk to you guys, you international people, as well as have my afternoon. So, thank you everyone for joining me. I'll play music for a moment from Epidemic Sound. Don't forget that I have a Discord chat server. We can join live chat and live voice sometimes. And I also have a podcast. We recorded another episode of the podcast, the Lawful Masses podcast, with me and Skeptic Sarah. And SidAlpha was our special guest star yesterday. So thank you very much to Sid. And as soon as my crew is done editing, because that's right, I have a crew. As soon as my crew is done editing, we will post that podcast to the link in the description. And thank you very much for joining us there too. SpaceX launch in 15 minutes. Oh, 1 hour and 51 minutes. Okay. We didn't miss the SpaceX launch. Whew. Okay. So now, I'm going to put this up on the screen so you guys can see what's playing. Of course, you can't see what's playing because my window is to... That what? What? It didn't help. All right. I wanted to show you what was playing, but it's not helping me. Oh, thank you for the Norwegian kroner 100 additional doggo money. Conversation goes to Discord. I'll be here for a moment. I'm a little sweaty now from having carried the dogs. And it's been great. I really appreciate all of you for joining me. It seems like there were a lot of you. Enjoy the rest of your Sunday, and I'll see you next week. I'm going to play some music for a moment here and turn off my mic and interact with chat, but I'll keep the stream going for about another 5-10 minutes while I also enjoy the music and my mouth full of dog hair. So, I'm your favorite copyright attorney, Leonard French. Thank you for joining me, and have a great week. Oh, also, thank you very much to my Patreon supporters and any other supporters, but the Patreon supporters specifically. I have several $50 plus donations that I'm receiving. Josh Meinsicker, John Cripps, John Steele, Backsorn, and Weston Loney are currently donating at the $50 level. Other supporters are donating at the $5 plus level. They are scrolling on my LED panel behind me, and they are in the description below. If they aren't already, they'll be posted there shortly. And if you want to join the Patreon, you also get access to the Discord with a special role, and so everyone can see that you're a donor. I can see that you're a donor, and you get your own special channel there too. And I try to interact with everybody on all the channels, but I also visit the patron channel and interact with you guys privately too. So thank you very much for joining me. I'm Leonard French, your favorite copyright attorney, and I will see you in my next video, probably
I'm so in love with you. You got me down again.
Okay, that's it. I'm gonna call it. It's out. It's done. Have a great Sunday afternoon, evening, and a great Monday and a great week. I'll see you tomorrow or whenever I get my next video out. Thank you for joining me.